Hello, my name is Keith Preston and I'm the attorney here at Preston Law Office. What you're about to watch is one video in a series that I've had made for the Law Office website to answer a number of questions that I seem to get on a somewhat recurring basis. I know that if I'm actually getting these questions, speaking with people on the phone or in person, and I'm actually answering these questions for a large number of people, that there's certainly other people that have those same questions that are either not only not talking to me, but may not be talking with anyone, and thus their questions are going unanswered. I wanted for the answers to these questions to be available on the website, for them to be available 24/7, and for people to be able to get that information. I'd certainly be willing to discuss these issues with you in further detail, or if you have a situation to where you believe that you need the services and advice of an attorney, we can discuss that also. You can contact me at either the phone number or email address that appears on this video, but also on the video page of PrestonLawOffice.com. But for right now, let's watch the video. Hi, this is attorney Keith Preston. The topic of our video today is, how does the probate process work? Well, we don't really have time in this video to describe the entire probate process because there are many if this then that type of situations. You really couldn't explain the whole thing. There are too many variables about if one thing happens and you go this way, but if something else happens you go this way, and it's just so on and so on down the line. But generally what I want to talk about is what effect does a will have without the probate process? And the answer is simple. If you have a will that names you as the executor and says, you know, who gets what and money and houses and all that stuff, if you have a will that describes the distribution of assets and that will has not been probated, that will doesn't mean anything. It does not give the executor any powers. It does not give any person any right to obtain any property or distribute anything or to do or receive anything. The only way that that will has any effect, the only way that that will has any authority, any controlling effect over any of the assets of that person that are to be distributed through that will, is for it to be admitted into the probate court. You file a petition, which is just a document requesting that the will be received into probate court. It has to meet certain criteria as far as witnesses and notaries and things like that. But you file a petition to admit that will to probate, and you file another petition asking the court to issue what is called letters testamentary. That's just a fancy word for a piece of paper titled letters testamentary that says so-and-so person is in charge of the estate of this person. The letters testamentary is what activates the will. It's what names the executor or gives the named executor any power or authority. The letters testamentary activate the will. They give the executor legal authority to handle the business of the estate. From there, it is a matter of following the provisions that are set out in the will and gathering assets and distributing assets, selling assets, wrapping up business, settling claims, paying bills, and doing whatever else is needed to wrap up the affairs of the person that is deceased. Hope that's helped to give you some information or answer some questions that you might have had. I'll be glad to discuss these matters with you further if you want to contact me at the email address or the phone number that appears on this video. Thanks for watching this video, and thanks for visiting PrestonLawOffice.com.